Super. Hello, everybody. Thank you for coming on this cold midweek evening. I'm Gavin Mansfield, Head of Littleton Chambers. Welcome you to our first face-to-face event of 2023. Our topic for today could not be more topical. We're talking about the retained EU law revocation and reform bill. It's so topical that it's being debated in Parliament this afternoon. I'm sure you'll all have been watching Parliament TV before you came over. As I turned it off, an MP was making the point that DEFRA, which has the largest number of EU laws that will need to be either retained or ditched, has got 3 full-time equivalent staff working on it. So that's perhaps a measure of the exercise that we're dealing with. We're going to try not to just throw our hands up and say, oh my God, what's to be done? Because that wouldn't take very long. We're going to... I'm going to tell you what we're going to do. I'm just here to host us and keep us the show on the road. You'll see a panel of talent to speak about this topic and to get discussion going. I particularly, though, want to introduce to you and thank Professor Catherine Barnard, who's here with us this afternoon from the University of Cambridge. We could not be luckier to have her join us, given her expertise and experience in this area. She is Professor of European and Employment Law at the University of Cambridge. She's the Deputy Director of UK in a Changing Europe and the author of several leading texts in the area of EU law. She hasn't asked me to, but I will draw to your attention that the 4th edition of European Union law is out in May of 2023, I think, is that right? And no doubt will be available from all good booksellers near you. And I commend that to you. It's an absolute seminal text. So what we're going to do is Catherine is going to start the ball rolling with a discussion about what the bill does and how it might work. I'm looking at her crib and it starts in warm, friendly letters with a section that says, what is retained EU law? So that's about pitched at my level, hopefully at yours. She's going to talk to us for a while. Then the Littleton Silks, who we have at the table, David Reade, Carol Davis, Niran de Silva, May Sethi, are each going to speak very briefly on a specific topic of employment law and how the bill may affect that particular area of law. That is designed to stimulate some discussion, and we'll have hopefully some discussion from the floor about the thoughts and ideas that have been raised. We're going to aim to wrap up the session by 7 o'clock sharp, and then we've got some drinks later on, and hopefully people stay and continue the conversation more in that. So without further ado, I'm going to hand you over to Catherine. Thank you.
Well, thank you very much indeed. Thank you for those kind words. It's always humbling when someone says nice things. You think, oh my God, I can only just disappoint, rather than things can't get any better than that. I'm going to talk a bit about the retained EU law bill. Gavin mentioned a crib. It's actually in your materials if it would help, because it's got some of the text of the provisions I'm just going to say something about. Obviously, I'm not going to read it through, but it's got the points I'd like to make, hopefully in a more articulate way than I can talk to them. So, retained EU law revocation and reform bill, known as the Rule Bill for short. And of course, in order to understand what it's doing, you need to understand where it comes from, which takes us back to the 2018 Act, the EU Withdrawal Act. That was the British Act. It wasn't one of the acts. There were a number of acts with similar names, but this was the Act, which was a British initiative. And the idea, indeed, the sensible idea behind the Act was to take a screenshot of all EU legislation at the time of Brexit Day, 31st of December 2020, and transpose it, bring it into UK domestic law as retained EU law. The only thing that didn't come across was the Charter of Fundamental Rights, but everything else, including the principle of supremacy of EU law, was transferred into UK law. Now, that's the headline. In reality, the way it was done was actually technically quite complicated. But I just want to say a little bit about the complexity, because you need to understand that to understand the unpicking that the rule bill will do. So in respect of retained EU law, Retained EU law at a high level is retained EU legislation. It's also retained EU case law and retained EU general principles of law. That is the big picture stuff. In respect of specifically retained EU legislation, it falls into two groups, which I've done a small diagram for you on the handout so you can see. And that retained EU legislation is first of all preserved legislation and secondly converted legislation. Now the preserved legislation essentially was preserving all of that law that had been adopted under Section 2.2 powers in the European Communities Act or under other bits of primary legislation. To give you a concrete example, working time directive was implemented in the UK using the Section 2.2 powers of the European Communities Act. Now, the problem was that with the turning off of the European Communities Act 1972, all of the legislation adopted under it would have been turned off as well. And so to stop that from happening, it was preserved by Section 2 of the 2018 Act. So that's preserved law, and so it was preserving any of the regs adopted under Section 2.2 powers, but also any of the regs adopted under other powers like the Health and Safety at Work Act or under any of the Employment Acts. So those were all saved. But in addition, you also have converted legislation, and converted legislation was mainly about EU regulations with a capital R, less relevant in the employment field. But if you think about regulations like, for example, the passenger rights compensation regulation, where if your Ryanair flight is late, you can claim compensation. All of that has been converted into UK law and goes by the unattractive name of retained direct EU legislation. The third thing that the Act did was to have a sort of sweeper provision in Section 4, and that sweeper provision basically saved directly effective rights. And that sweeper provision saved directly effective rights, and that is important in our field because it covers, in particular, Article 157 on equal pay for men and women. That was preserved under Section 4, and as was any unimplemented or incorrectly implemented directive. That was also probably, although there's some argument about that, preserved under Section 4. So that is an overview of what the 2018 Act did. It saved, it had preserved legislation, Section 2, which is basically the directives to make sure that they didn't lose their legal basis. It preserved under Section 3, converted legislation, so those are regulations, and it saved, thirdly, directly effective rights in Section 4. So it was always intended as a holding pattern. It was always intended that the government would then use the time it had to turn off or amend that legislation to make it more suitable to the UK. And the problem is that some of the Brexiteers thought that the process by which that process of review and assessment was taking too long. And it's certainly the case that from 2018 to today, only 196 pieces of rule, retained EU law, stuff I've been talking about, have been repealed and 182 have been amended. Jacob Rees-Mogg became Brexit Opportunities Minister, and the rule bill is very much his baby. And it is worth just knowing a little bit about him because it helps you to understand the bill. Now, as you can see, there's lots of stuff he's written. I've given you an example there of a piece from the Daily Telegraph. He sees all of this EU law as red tape. But he is a parliamentarian, and therefore he always thought that primary law, so any EU law implemented through primary law, which actually is retained EU law, but any EU legislation which was adopted via primary law should not be affected by the rule bill, which is why, for example, the Equality Act 2010 is outside the scope of the rule bill. The Equality Act 2010 is not affected by the sunsetting in the rule bill. So Jacob Rees-Mogg, determined to get rid of all of this red tape as he saw it, it is worth remembering that when what he calls red tape, other people might call quite important principles, for example, workers' rights, environmental rights, consumer protection, food safety, airline safety, gas safety. All of this is retained EU law, and this is what he calls red tape and should be turned off. And that's what he tried to do. Lord Frost had advocated it already, that there should be sunsetting of all of retained EU law. But it wasn't just sunsetting of all of retained EU law, it was also turning off the supremacy principle, turning off general principles of law, giving a decent shove to the judges to make them a bit more enthusiastic about departing from case law of the Court of Justice and the British courts. And then the other thing this bill does is to give ministers considerable power to restate the law, and I'll come back to that in a moment. Now, the headline, of course, of the rule bill, which was tabled by Liz Truss in the brief window when she was Prime Minister, is to sunset all of retained EU law. Now, I say sunset. In fact, if you look at the bill contains two sunsets, as the bill describes it. First of all, there is the sunsetting of subordinate legislation and that rather ill-named retained direct EU legislation. I'll come back to that in a moment. But it also sunsets anything under Section 4. And you'll just remember when I told you about Section 4, Section 4 was a sweeper provision in the 2018 Act. And Section 4 is the provision that gives effect to Article 157 on equal pay, and it also saves any unimplemented or incorrectly implemented directives. That is also being sunsetted. Article 157 on equal pay is being sunsetted under the bill. It's clause 3 of the rule bill. But where the most dramatic provisions are clause 1, the sunsetting of EU-derived subordinate legislation and retained direct EU legislation. Now, I realise this terminology is pretty rebarbative. And so just to remind you, EU-derived subordinate legislation is all of that preserved EU law I talked about at the beginning. So anything adopted under Section 2.2 powers, Section 2.2 of the European Communities Act, that is EU-derived subordinate legislation, as is any statutory instruments adopted under any other powers which have similar effect. So to give you a concrete example, you can look at the working time regulations. They will be turned off, at least in principle. They will be turned off because they are an example of EU-derived subordinate legislation, and that was adopted, and they were adopted under Section 2.2 powers, so that is covered. But also the fixed-term employees prevention of less favourable treatment regulations, they will be sunsetted. They weren't adopted under Section 2.2 powers. They were adopted under Sections 45 and 51 of the Employment Act 2002, but they have the same function as the Section 2.2 legislation. So that is covered and therefore will be turned off. And then in addition, what's also being turned off, although less relevant in our field, is retained direct EU legislation. So things like the passenger rights regulations, they will be turned off too. So headline is turning off everything. And that is the default position in clause 1.1. There are some exclusions. I use that term loosely, not in a very legal sense, because I'm not sure they are proper exclusions. The first is, as I've mentioned, primary legislation is not affected by this bill. So the Equality Act 2010 should not be affected by this bill. And that goes back to the point I made to you about Jacob Rees-Mogg. Then, bizarrely, there are whole other swathes of areas of law which are not going to be affected by this legislation, but you can't see that from the face of the bill. You see it from the press release that accompanied the bill. And I've put the key quote from on the handout, but it's basically anything to do with tax is being treated entirely separately. though, as I say, you do not know that from the face of the bill. And also financial services probably kept treated separately because the Financial Services and Markets Bill that's going through. I'm not going to dwell on that because it's less relevant for this audience. Then there is apparently going to be a third exception, exclusion, whatever you want to call it. But again, you don't see it on the face of the bill. But that is international obligations. The government committed itself on the floor of the House to respecting our international obligations. If you dig around on the government website and you look on, for example, the intellectual property pages of the website, you will see the government says we are going to save provision, anything contained within the Northern Ireland Protocol, the withdrawal agreement, and other international treaties. What they don't mention there, although presumably is implied, is the Trade and Cooperation Agreement. That's the agreement on which we are trading with the EU now. Now, as you know, the Trade and Cooperation Agreement has a level playing field provisions in it. And the level playing field provisions, there are a number of them, but I've set out the two that seem most relevant to me. And that's Articles 386 and 387 of the Trade and Cooperation Agreement. Now, the TCA, Trade and Cooperation Agreement, says in Article 386 that, yes, the UK can change its laws in the field of labour law and does much the same in respect of environmental law, and then lists the areas which are covered: fundamental rights at work, occupational health and safety, fair working conditions, information consultation, and restructuring of undertakings. So, of course, by turning off all of employment law, that would directly affect anything in these fields. Now, here's the catch. If you look at Article 387, paragraph 2, it's in bold, it says a party shall not weaken or reduce in a manner affecting trade or investment between parties its labour and social levels of protection. Now, if the government says it's going to respect international law, let's assume that we take them at face value, and that means respecting the Trade and Cooperation Agreement. That you might think, well, that's all right, then labour law is going to be safe because the government will not want to have triggered the provisions, the level playing field provisions in Articles 386 and 387. And if those provisions are triggered, it can lead to the imposition of tariffs on UK goods. There is a process, but that's the end point. But what happens if the government decides not to take a scythe to all UK employment legislation, but tweaks it a bit, gets rid of the bits that they think are inconvenient? Will that be considered enough to trigger the provisions in Article 387.2? Does it just tweaking the provisions, taking out the provisions on rolled up holiday pay or sick leave, will that be enough to trigger 387.2 that the effect of what the UK is doing is affecting trade or investment? So I know that's quite complicated, but what I'm saying here is that you could say labour law might be all right because of the government's commitments to respecting our international obligations. I've just seen on Twitter that the minister has insisted that she is not going to engage in a wholesale deregulation of workers' rights. But there is a difference between wholesale deregulation of workers' rights and changing, altering, affecting them in some way, but in a way that falls below the standard of in a manner affecting trade or investment. So, headline is that we are in a fire sale. Everything must go, and it will go by the 31st of December 2023 if the bill comes into force. So what are we talking about? Well, I've already referred to some of the labour law that might be affected, subject to the government's commitments in respect of respecting international obligations. But what we do know is the sheer volume of legislation that's being affected. The government thought there were 2,400 pieces of retained EU law, and then suddenly in October, another 1,400 pieces were discovered down the back of the sofa. The problem is we don't know what we don't know. We don't know what other bits have been missed. And what's really striking, the government dashboard, which I've reproduced for you, looks very pretty, but it hasn't been updated even with the 1,400 pieces that have been recently found, let alone the other bits that might have been missed. It's thought there are about 800 orphan pieces of legislation, retained EU law. And by orphan, I mean they haven't got a sponsoring government department anymore because of machinery of government changes. So what happens if there are other bits that haven't been thought about? So one of the amendments that's being debated this afternoon is a requirement that the government list all of retained EU law as they know it, so that at least MPs know what falls within the scope of the legislation. Now, whether that amendment will pass is not at all clear. It may be that the Lords will have another go later on, but at least that would give some clarity to avoid the unknown unknowns problem which we are currently facing. There are also unexpected consequences. There's a very good example given by the British Safety Council. It's on the margins of our area, but in respect of new legislation post-Grenfell, the new legislation, the Building Safety Act 2022, is premised entirely on definitions which are in 2015 regs, the Construction Design and Management Regulations. And of course, those regulations will be caught by the sunset. And so there may be many other examples of this. These examples are just coming forward. So there are unexpected consequences. There's also a huge capacity issue. Gavin's already mentioned that to you. If you just look at the report in the FT, DEFRA, Department for Agriculture, and BEIS in particular are really worried about capacity issues. BEIS has 300 pieces of EU law for which it's responsible according to the pre-October discovery of all sorts of new things. And if you just do the maths, there just aren't enough days to do the review, even assuming you can work through one piece of legislation every day between now and the 31st of December. There are also major issues for devolution because the devolves have even less capacity, and a number of these areas do touch upon devolved competences, and there are major issues facing the devolves. And if you're interested, there's some very good work on the Senedd, the Welsh Assembly website, setting out just the problems that the devolves are facing. We also know that all of this is going to have to be done in an incredible rush, because if the government is going to stick to the deadline of the 31st of December 2023, then the reality is we know mistakes happen. And the reality is, again, we just don't know what is actually going on, because as the Regulatory Policy Committee put it, in the most coruscating report I have ever seen from a committee of this time, the impact assessment on this bill is totally inadequate. Everything about this bill has been subject to red lights. It is worth just reading the first page of that document if you've not done so before, to see what concerns BEIS's own independent committee has about this bill. So I've told you the worst, which is everything must go. It is a fire sale. It's dramatic, and all of this will come to a head at the end of 2023. Now, of course, there are provisions in the bill to save some of this legislation, and the bill essentially allows for three possibilities: keep, delay, and restate. Now, keep, that's the interesting one. Clause 1(2) of the bill essentially says that any relevant national authority, that is Whitehall and the devolves, can pass regulations to say we want to keep this legislation or bits of this legislation. And the crucial thing about the powers in clause 1(2) is there's no deadline set. So it's basically kept forever, or subject to the time when the government wants to review it properly. If it is kept using these powers, it will be called assimilated law. And the key thing about assimilated law is the word European isn't there. And therefore, it will be shed of any European attributes, in particular, any European methods of interpretation. So as the government says, if it's assimilated law, then EU interpretive features will no longer apply. The problem about using that power, there is nothing in the bill as to when that power will be used, how that power will be used, whether there's going to be any consultation over the use of that power. And there is a real concern what happens if ministers just sit on their hands and do nothing. If they do nothing, then you get to the cliff edge again, because that is the default. So that's keep. Secondly, delay. So clause 2 allows a minister of the Crown, i.e. Whitehall only, not the devolves, to delay the sunset until the 23rd of June 2026, 10 years after the Brexit vote. But again, you need regulations to actually say we are keeping we're delaying the following sunset until the 23rd of June 2026. Some government departments look like they may use those powers quite extensively, others will not, and there's huge pressure from the Brexiteers not to use those powers. And then there is also the powers to, these are the controversial Henry VIII powers, to restate EU law as to make it a bit more British. And interestingly, the restatement powers in clause 12 and clause 13 are meant to be there to resolve ambiguities or to facilitate improvements in clarity, but they also allow for supremacy to come back via the back door and general principles of law, things which are turned off elsewhere in the bill, but they won't be EU supremacy, but they'll operate like EU supremacy does. I mean, it is extraordinary way of legislating, but if Bayes decides it wants to reintroduce the supremacy of Article 157 on equal pay for men and women, it can do so, and it can use the powers in clauses 12 or 13 to deliver that. The most controversial clause in the bill is clause 15, and clause 15 is remarkable. It allows any minister to revoke any secondary EU law without replacing it, revoke and replace it with something that they like the look of better with the same or similar objectives, or to revoke and make such alternative provision as the relevant national authority considers appropriate. That means, for example, if they want to shave some bits off the working time regulations, the bits they don't like, they can do so, not least because you can use the clause 15 powers as long as it doesn't impose regulatory burdens. And what do regulatory burdens mean? Well, in clause 15.10, we're told any changes made under clause 15 mustn't increase administrative inconvenience or financial cost. Again, no provision as to how and when those powers should be used. A couple of other points, then I'll stop because I've made the main points. Supremacy of EU law, as I've said, also being turned off. And the Marleasing principles will also be turned off, but again, there's power to turn them back on. Likewise, general principles of law, those are things like effectiveness, proportionality, fundamental rights, they all go too, but with the power to turn them back on. And as far as the courts are concerned, there is a very strong nudge to the courts to be a bit more enthusiastic about Brexit and to depart more enthusiastically from retained EU case law. And there are some grounds given to justify that departure, for the extent to which, for example, EU case law restricts the proper development of domestic law. I haven't a clue what that means. To conclude, this is a bit like a hokey cokey. You have something turned off, a lot turned off, but with the power to turn it back on again, but also with the power to turn it off again. It is really somewhat surreal. The reality is huge uncertainty will be generated by this legislation. And even if the powers in clause 2 are used to delay the sunset till 2026, it will have a very significant chilling effect on investment, because investors just don't know what the law is going to be in 2026. There is a rather remarkable coalition of interest groups, all campaigning against the bill, including the excellent Employment Lawyers Association, who've done a very good briefing, which I commend to you, who express grave concerns. Bottom line is huge uncertainty generated by this bill. Nothing to stop the government just using ordinary powers to change employment law that they don't like, but this is not the way to do it. Thank you very much.
Well, Catherine, I'm sure everyone will agree with me. That's an incredible tour de force on these principles. Fantastic clarity in your explanation of both how the bill works and some of the problems with it. But also, I think you'll have delighted a number of members of the ELA L&P committee who are with us this afternoon with your remarks about that. What we're going to do now, before we open the floor to discussion, is just get some food for thought from the Littleton members of the panel on some specific areas of law. And we're going to keep this, everybody, short and to the point as to the issues to think about. We're going to start with David Reade at the end of the table on the question of TUPE. Always on the question of TUPE.
Always on the question of TUPE. Yes, thank you, Gavin. Can I just confirm an important piece of information I've now established, that the 1,000 EU laws stuffed down the back of the sofa were not stuffed down the back of Jacob Rees-Hogg's sofa. He has a chaise long. Not actually possible to stuff any regulations anywhere near it. Now, of course, the most burning question on your lips when it comes to the impact of this law on TUPE is what's going to happen to Charlie Wynne-Evans' royalties. Well, the bad news is they're not looking good, because what we know is that the transfer of undertaking regulations were directly made under the European Communities Act 1972. So as they stand, if nothing changes, they leave us. Now, is that completely the answer? Well, actually, there is a wrinkle in that. The wrinkle in that simple statement is service provision change, because service provision change was not made under the European Communities Act. And we know from cases like Hunter and McCormack, actually, when you look at service provision change, it isn't affecting any community-based obligation. It's an entirely domestic creation. And you don't apply principles to conform with community law in deciding whether or not it amounts to a transfer. So actually, that definition is not revoked by the Act. But how can that work? It's a bit like building a lecture theatre on top of an existing building and suddenly finding the existing building has been knocked down. Because all that service provision change is a gateway provision. When you look at the regulations, you see the two definitions of transfer. EU, I like to call it full fat, and service provision change, TUPE light, and then you see them funneling into rights, but all the rights and obligations disappear. So is there anything left? Well, I had a trawl round to see if I could think of anything that might be left, and I landed on the Pensions Act 2004, because rather surreally, the Pensions Act 2004 exercises the discretion that we had in the UK to deal with particular provision about pensions and occupational pension schemes in cases of transfer, and it builds in obligations. But it uses a generic definition of transfer from the regulations. So if you really wanted to be techie, you could say, actually, service provision change stands, and it's still a transfer for the purposes of the Pension Act. So fantastic, whoopee-doo. If you are fortunate enough to be in an occupational pension scheme, and it's technically a service provision change, you might have some rights to retention to your pension or provision in relation to it, but nothing else. All your other rights about provisions restricting variation of your terms and conditions, information and consultation, and dismissal protection, they've all disappeared. So what will be left? Well, very little. What would be left is, and we're digging back into history here, Section 218 of the Employment Rights Act. And there's only really been one case in the last few years that looked at that. That's the case that says that if there's a transfer of a business, people retain their continuity of service. Now, if you look at the Act, you don't find transfer defined. That provision predates TUPE. Dates back to the early provisions of continuity prior to 1981, and you won't be surprised to find that the last case about what it means is around 1981, because after that no one had to bother with it. But actually, we'll go back to presumably having to work out whether or not there is a transfer. It doesn't transfer people. It only provides for continuity of service if you're employed by the person that's taken the transfer of a business. So there's some little semblance of TUPE left, but really nothing by way of substantive rights. So is there going to be a groundswell to oppose that? Well, of course, there's some real problems with the disappearance of TUPE. All of us have encountered businesses that have built their business model around TUPE. People who rely upon the protection of TUPE around the movement of workforces to deal with the ebb and flow of worker demands when they lose or gain contracts. The prospect of TUPE disappearing will mean they may be left with the costs of meeting terminations or redundancies the next time they lose a particular contract, and they don't see the workforce moving on the merry-go-round to the next incoming service provider. Now, a lot of those businesses may say, we really expect TUPE to stay. Of course, it's interesting to know that way back in the days of the coalition government, when they undertook a review into TUPE and were contemplating abolishing service provision change, the general groundswell at that time was to keep it. Now, of course, I don't know whether that was because businesses were saying, well, we're stuck with TUPE and actually service provision change is clarity, or whether in fact people were articulating the need for TUPE because they recognised it had a commercial economic viability in the marketplace. The other area I think is going to be very significantly impacted, and again, it's a bit of TUPE where we elected to make discretionary decisions, is the area of insolvency and administration. We chose, because we had a discretion under the directive in 2006, to put in some aspects of defined TUPE restrictions, limitations on the effect of TUPE in cases of insolvency, because we wanted to encourage a rescue culture to preserve jobs in businesses out of administration. Well, has that suddenly become a bad thing if it disappears as part of TUPE? Is that not something where we had an idea as part of insolvency and administration that we wanted to secure transfers in order to preserve employment in insolvent situations? Will the world look very different for people if they're looking at buying out of insolvent businesses? Will it encourage it or diminish it if you can suddenly say much more freely than you could before, actually, I'm not taking staff or I'm changing terms and conditions? That may be a driver in the opposite direction. Now, of course, what we might have is a view that we should keep TUPE. Even if we keep it in the form of the regulations, things will, of course, change. Things will disappear. Maybe the greatest thing to disappear is we won't have to work out what ISS services and goverts means in the context of service provision change. We can happily push to one side a decision of the Court of Justice. It's difficult. Concepts of EU principles and earlier decisions, of course, would disappear, and we go back to a much more literal interpretation of TUPE. I'll confess my ignorance. I didn't even know about the EU abuse principle until I found that I'd breached it in a case called Ferguson and Astrea. But I wouldn't even need to worry about it in the future because that's part of the substrata of EU law that wouldn't impact. So we could keep TUPE, but we could keep TUPE in a non-EU environment, but with much more literal interpretation than we've had before.
Thanks very much, David. Next up, Niran, working time.
Working time. I'm going to be talking about the working time regulation, which of course always come up in the context of revocation because it's quite clear they're right in the sights of the bill. Firstly, as Catherine has said, almost all of it is EU-derived subordinate legislation adopted under Section 2.2 of the European Community Act. So they're therefore forced to be sunsetted or turned off, to use Catherine's phrase, come the end of the year. The same is actually true of the agency workers regulations, which provide that agency workers would have the same rights, including in relation to, for example, rest breaks, as directly employed workers. And the second point is that despite what's been said by the government, including this week, about protecting workers' rights and this not being an attack on workers' rights, as we know, the working time regulations contains exactly the sort of workers' rights that were discussed in Brexit, the abolition of which was said to be one of the very advantages of leaving the EU. So without a positive decision that they're kept or delayed or restated, effectively it all goes at the end of the year. So I'm just going to look very briefly at the three main areas covered by the regs before looking at some European case law. Firstly, the maximum working week, again, the subject of much criticism amongst some politicians and some sections of the media. The sunsetting of the maximum 48-hour week might be totemic in some way. But in reality, in this country, the 48-hour week actually perhaps isn't that significant. I was discussing with Catherine an article that she wrote back in 2003, soon after the regs came in, about the very widespread use of the opt-out that we have in this country. And that opt-out is still very widely used, not just in law firms and banks, but also on shop floors and factories. So being in such wide use and the availability of that opt-out to managers, one would think it may be unnecessary to sunset the 48-hour working week. There are also maximum hours provisions in various sector-specific legislation dealing with airline crews, road hauliers, and sea fishermen. But again, those are safety critical provisions, and they are necessary. The reason they were introduced is because there's specific safety issues arising in those sectors. So it'd be hard to see that they're obvious candidates for sunsetting. Briefly on rest breaks, nothing that we get too involved in when it comes to litigation, but a very important set of rights. For example, the 20-minute rest in a 6-hour shift, the 11 hours of rest in a 24-hour day. But again, if the government is going to protect any workers' rights, as they emphasised this week, they would. But again, it's hard to see that such minimum rights be among the rights that they wish to sunset. Of course, really, when we talk about the working regs, most of the litigation is around holiday, annual leave. And it's worth just perhaps remembering that back in 2007, the government, admittedly a different government, but the government introduced an amendment to the regs with some additional leave beyond the European leave. This is entirely domestic, untainted by Europe, an additional 8 days that workers were entitled to here. So I think it probably, to a degree, goes without saying, it's unlikely, given the government introduced it, that they would see this as something they should reduce because it is not European in nature. But that doesn't mean there won't be tweaking of the kind that Catherine's described in relation to holiday. For example, rolled up holiday limitation even. But of course, tweaking needs a bit of thought. It needs resource, which, as you've heard, the government doesn't seem to have access to. It might need, for example, consultation, which looks like it's not going to happen given the headlong way in which the government's addressing all. So much for sunsetting of the regulations themselves. I want to just say something next about the European case law, which, as you know, has conferred various rights on workers, rights which do not arise from the wording of the regulations themselves. And the point here is that the abolition of, for example, direct effect rights, the supremacy of EU law, the general interpretive provisions of EU law, the abolition of all that will mean the abolition of certain rights that workers have. So, for example, there's the right of a worker to carry over holiday where they've been deterred from taking holiday by an employer who refuses to pay holiday. Either, for example, they don't recognise them to be a worker, or they think the entitlement is different to that claimed by the worker. This is the king and sash window point. There's the right to have included in holiday pay bonuses and commission. That's, for example, Lock and British Gas. Overtime, different kinds of overtime, as in Bear Scotland and in East of England ambulance, those rights are European in origin, not directly from our regs. There's a right of the sick worker to carry over leave for a period of up to 18 months, the Leeds and Lana point. So all these rights could potentially be saved in some way by the government, but it would need some active step on their part. For example, to replace the working time regs with something different, for example, under clause 15 of the bill, which can be done, as Catherine said, to achieve the same or similar objective to the existing regs. There's no particular reason to think the government would have appetite for that, leaving aside the politics of it. The extra 8 days that we have that are domestic in origin, the government's never amended the regs to include the European rights to holiday pay, including bonuses and commission and like, into those additional 8 days. So whoever ultimately makes the decision as to what stays or what goes, currently the minister or sometimes the devolved, if there's amendment, it might be MPs who decide that. There are a range of outcomes for all legislation. There's keeping, delaying, restating, reproducing, revoking, replacing. But at this stage, particularly given the headlong way in which all this is being addressed by the government and the lack of consultation, it is somewhat hard to predict what that outcome might be. Thank you.
Thanks very much, Niran. Carol Davis, discrimination.
Thank you. Well, from a discrimination point of view, the question is, are equalities protections safe? Well, the government certainly wants us to believe that it is. Their equality impact assessment for the bill says that equality protections are safe because they're largely contained in the Equality Act, which is domestic primary legislation. And as Catherine says, that's not going to be repealed. And in today's media briefings, Grant Shapps has insisted that there's absolutely no truth whatsoever with the idea that employment rights will be scrapped, and the sooner they stop peddling this stuff, the better. Well, I assume that Grant Shapps is going to accuse Unison of peddling untruthful stuff because Unison has described the bill as an attack on working women. And they argue that the bill is going to, in fact, smash a wrecking ball through decades of hard-won protections for women in the workplace and throw women back to the 1970s. And I'd say that not all is bad about the 70s, but that might give you a clue as to my age. Now, I think it's premature to be describing the bill as a wrecking ball, but I do think that there has to be real cause to be concerned about the impact of this bill on equalities and discrimination law. Now, we know in the UK that about 40% of full-time workers are women, whereas approximately 70% of part-time workers are women. And we also know that more women are fixed-term workers. Now, both the part-time workers and the fixed-term employee regulations afford valuable protections to part-time and fixed-term employees. So, for example, the part-time worker regulations prevent employees being treated less favourably in comparison to their full-time counterparts in terms of their contractual terms, and that applies to matters such as basic rates of pay, shift allowances, contractual sick pay, holidays, career breaks, parental leave, maternity pay and maternity leave and other family leave, fringe benefits and access to pension schemes. So quite a lot. If those part-time regulations go and are not replaced with comparable rights, arguably that is going to have a disproportionate adverse impact on women in the workplace. And another clear risk is to the protection of pregnant workers and the rights to maternity and parental leave. Now, it's right, of course, that key rights are afforded to pregnant employees or employees on parental leave, both in the Equality Act and in the Employment Rights Act. But much of the detail in respect of those rights is contained in regulations, including the Maternity and Parental Leave Regulations 1999, which implements EU directives on parental leave. Those regulations, as Catherine said, as an EU subordinate legislation and will no longer be enforced unless they are preserved, restated, or replaced. Further, maternity rights, both in the Equality Act and the Employment Rights Act, will no longer be interpreted in accordance with general principles of EU law, which means that going forward, huge legal uncertainty is going to be created, which has got to be an undesirable position, both for employers, but also pregnant employees or employees of a childbearing age. Now, that's not the only headache that's going to be caused to employers and pregnant employees. Again, by way of example, the Management of Health and Safety at Work Regulations 1999 implement health and safety requirements of the Pregnant Workers Directive into UK law. Again, those regulations would be turned off by the bill. Now, again, it's right that women of a childbearing age and new and expectant mothers would still have a measure of health and safety protection under both common law and primary legislation, such as the Health and Safety at Work Act and the Equality Act. But employers' obligations are going to be far more prescribed and far less certain if the regulations go. By way of another example, cases in the European Court have provided clarity on the scope of employers' legal obligations in relation to risk assessments for new and expectant mothers, and on the approach that the court should take in determining whether a failure to conduct an adequate risk assessment or to act on its findings may amount to discrimination, and that guidance would go. Catherine also mentioned equal pay, which we all know is a complex area which affects mainly women. And of course, EU law has shaped and influenced equal pay law over the last 4 decades and has brought clarity and protection to female workers, for example, in terms of who they can compare themselves to, what amounts to a stable employment relationship during which the employer is liable for inequality, and establishing how discrimination can be shown. Now, Catherine also mentioned Article 157 of the Treaty on the Functioning of the European Union, and that's far less restrictive to equal pay claimants than Section 79 of the Equality Act. And under Article 157, a claimant is able to compare herself against an employee where terms and conditions are attributable to a single source. And most recently, that's enabled female supermarket shop workers to bringing equal value claims to compare themselves with male colleagues working in distribution, a comparison that would not have been possible under the more restrictive provisions of Section 79. Now, in the event that that EU concept of single source is removed from equal pay law, not only does that run the risk of reducing the scope for workers to successfully pursue claims in the future, it also has a slightly bizarre consequence that some claimants will have live claims reliant on the single source test, while future claimants with the same claims will only be able to rely on domestic law, which is giving rise to different gateways into the same litigation. Now, the bill also raises the prospect that legal arguments about interpretation of various statutory rights will be reopened, again creating huge uncertainty and the risk of expensive, drawn-out litigation in an already overburdened tribunal system, followed by appeals and satellite litigation. And one wonders, for example, are we going to find ourselves re-arguing what amounts to less favourable treatment under Section 13 of the Equality Act, or other absolutely core discrimination concepts that are underpinned by EU case jurisprudence and principles? And I think one also has to wonder too whether future attempts might be made to cap compensation for discrimination. And if you cast your mind back to the consultation which preceded the introduction of fees to the Employment Tribunal, the coalition government at the time proposed some form of cap on compensation if the claimant had not paid a fee at an appropriate level. But ultimately, during the consultation stage, the government acknowledged that actually European law prohibited the setting of a fixed cap on discrimination awards, and effectively, therefore, the government is restricted in its policy options available to address the concerns that it had about uncapped compensation. And it was really implicit in that acknowledgement that the government may well have capped discrimination awards had it not considered itself constrained by EU laws. And we often hear about the government justifying action because of businesses' fears of high awards, and Rishi Sunak today talking about the importance of growth and facilitating growth. And one has to wonder, might promoting business growth be used as a justification for taking action to limit employers' exposure to liability for discrimination, and particularly large discrimination awards and equal pay claims? Now, it's obviously true that we just don't know at the moment how this bill will develop. But it seems to me that the equality impact assessment is simply not right to suggest that equality's protection is safe. And I think there has to be a real danger that those with protected characteristics are threatened by this bill. And in particular, there's real cause to be concerned that women in the workplace will bear the brunt of many of the consequences of this bill. And that's me.
Thank you, Carol. And we'll wrap up with Mo Sethi on some general community principle points.
Well, thank you very much, Gavin. In this quite extraordinary everything must go fire sale, as Catherine has described it quite accurately, what we're getting is a turning off, a switching off of EU-derived employment rights contained in secondary EU-retained law. That's the preserved law element that Catherine was talking about. And secondly, in retained directly effective EU legislation. That's the converted law that Catherine referred to. But secondly, and that's dealing with just the keeping, amending, revoking, replacing of secondary and directly effective legislation. But what's interesting here is that what the bill also expressly does is that it stops EU law from being supreme. That's in clause 4, and taken together with the deletion of the direct effect principle of general principles of EU law, which are used to interpret EU cases. It means that we've had this, what we've gathered in terms of a half a century of settled interpretation and meaning in terms of the ambit and effect of EU law on domestic matters, simply vanishes overnight. That's half a century of interpretive case law. And it's that area that I just want to focus on, because it's one thing to abolish and replace EU derived regulations, which are within the scope of the bill. It's quite another, and to replace those that you have perhaps abolished. But it's quite another to abolish but not replace the 3 key interpretive principles that are fundamental to EU law. And those are effectively these. The takeaways are that its direct effect is going overnight, supremacy of EU law is going overnight, and general principles of EU law is going overnight on New Year's Eve this year, unless replaced in some form. The bill does, however, on that point, make some provision for replacing those 3 interpretive principles, but that requires, as has been mentioned earlier, positive action on the part of the government, and we haven't seen any real guidance and indications to what the government intends to do in that regard. Now, whilst the government's online portal, there's a public dashboard that's available to show which particular regulations have been identified by the government, and those don't contain all of them. That's far from satisfactory in relation to indicating whether the government's really thought through how cases will be decided once either general principles, for example, have been abolished and not replaced, or what they're going to be replaced with. So looking at those areas, principle of supremacy firstly. The principle of supremacy, as you know, operates as a way of interpreting EU law when there's a degree of uncertainty. Now, it's clause 4 that completely does away with supremacy of EU law. It's clearly a key component of Rees-Mogg's intentions and the key purposes behind Brexit. It expressly adds words to the effect that to the 2018 Withdrawal Act, to the effect that the principle of supremacy is no part of domestic law anymore after the end of this year. And it goes on to explain that the provisions of direct EU legislation must be read and given effect so as to be compatible with domestic laws, and that they are subject to domestic laws if they are incompatible with them. In other words, reversing the current position. There is this clause 8, however, which confers powers on relevant national authorities to make regulations that disapply the effect of clause 4 in respect of specific provisions. In other words, it enables particular provisions to be retained of direct EU legislation to take priority where it be incompatible with domestic enactments. But the concern here is that the government simply doesn't have enough time between now and the end of the year to conduct a proper analysis of that. And when it comes to the general principles of EU law, it's one important general principle is the principle of effectiveness. You'll recall that's the one which provides that EU rights or rights at the subject of EU law must be enforceable effectively. It's been deployed in a great many cases here and abroad, for example, to hold that any employment right should be given effect, to not be so hard to enforce as to be pointless, for example, such as when an employer deliberately misleads a worker about their right, say, to holiday pay. A second important fundamental principle of EU law, which goes, is the Marleasing principle, which Catherine briefly mentioned. That's been used by courts many times, so that until the end of 2023, if a directive can be seen to grant solid, clear, defined rights and to be enforced and to be implemented, or need to be implemented by a member state, then that's to be given conforming interpretation with the purpose or object of the directive. And now clause 5 completely does away with that. It adds words to the effect, words to the 2018 Withdrawal Act to confirm that no general principle of EU law is part of domestic law after the end of 2023. But remember, general principles of EU law are not just principles of effectiveness, of Marleasing, or they include principles of non-discrimination, principles of fundamental rights at treaty level, such as the Equal Pay Article 157 provision that's been referred to by both Catherine and Carol. What then is the practical effect of abolishing not just direct effect, not just supremacy of EU law, but all the various fundamental principles of EU law as well when it comes to interpreting these provisions? Well, the interpretive obligation has to at some point be replaced by some form of domestic case law. But there have been a great many cases where domestic case law simply has not gone far enough and has had to be rescued by principles such as effectiveness in order to find an answer. And it's that vacuum which will need to be filled in some way. You'll know that where the regulations give effect to a directive, such as, for instance, in the case of the Working Time Directive, as Niran referred to, the courts use the directive to help them understand the meaning of the regulations. And unlike domestic law, in directives, their object and purpose, the point of the exercise is set out and the aims are set out in recitals. So the courts often have recourse to that in interpreting matters. But as a result of EU law currently having supremacy over UK law, the court is informed in its understanding of the purpose of the directive by the Marleasing principle, by the principle of supremacy of EU law, so as to interpret domestic legislation to give effect to those intentions of the directive. But if you don't have principles like that at play, what's that going to be replaced with? We've heard examples as to what's going to happen in the world of TUPE, what's going to happen to working time, and Carol's dealt with discrimination. There are a great many other areas. Take atypical workers, for example. So here, as Catherine said, the bill switches off. It completely abolishes the rights of part-time employees, the rights of fixed-term employees, the rights of agency workers, as Niran referred to as well. Now, the rights of atypical workers depend to a large extent on the application of these three principles that are just going to vanish overnight. Take the definition of Limb B worker status, or in the discrimination context, the definition of employee. That's been read as a result of EU law and has extended also health and safety legislation and rights, and many other rights, such as holiday pay and discrimination law to a wide range of workers, gig economy workers, for example, other atypical workers. And we have seen through the worker status case law that it's taken a great many years to just come to the position of, for example, the Uber case in the Supreme Court. Are we now going to be facing a new period of time where we're not going to get to a settled point of interpretation for a good many years because we're following a different set of principles? I mean, atypical workers are the ones that are the most vulnerable. They're the ones that benefit most from statutory rights protections. And they are less likely, for example, to have contractual benefits to holiday pay and the like. And so we we've got to a position now, a settled position, where Smith and Pimlico is a case in point, which has used EU principles of effectiveness and the Marleasing principle to develop rights to holiday pay for atypical workers. But all that goes overnight. It's all open shooting season and up for argument again. There are other areas, collective consultation, which hasn't been mentioned today, or parental leave and matters of that kind, which will be significantly affected. And the problem is that the common law now will have to, as I say, take some time to develop a settled understanding. And the uncertainty that's going to be created is going to be great news for us lawyers, because, of course, there's going to have to be a great many cases fought in the EAT and on appeal. But the problem is that the uncertainty for workers and employers, which is, as I say, fertile ground for litigation, in view of the backlog in the tribunal system currently, any case, let's say from January of 2024, which comes on, it's probably not going to be heard until 2026. Then you'll get a decision of the ET, which is a non-binding decision, and you'll have to appeal to the EAT and beyond to get a binding decision. But there are two other interesting aspects. There's which I don't think has been mentioned, Catherine, yet, which is the ability of parties to, as it were, make a reference up to a senior court for an interpretation on it. That gives us another quite powerful tool for litigants to use. And also there's the equivalent in terms of almost like a declaration of incompatibility that arises. The other point is this, I suppose, to bear in mind, that even where retained EU law is preserved, so in other words, we're keeping it, we're going to keep it as it is, but we're keeping it as it is without the principles that informed it and that built it, but we're going to now apply English principles to it, or UK principles to it. There's considerable scope for reinterpretation there across the board. And it does allow for greater scope for the UK courts to depart from retained EU case law. It increases the potential for revisiting these principles that were previously, as I say, considered really quite settled. And the prospect of the UK courts taking a different approach from that previously taken by the CJEU is vastly increased by the fact that the courts will apply different rules of interpretation. We're not quite clear what they will be yet, to EU-derived legislation, in particular because of the Vanishing Act that will occur to these three areas of principle. That's really all I wanted to say. I think the last thing is really just to observe that one thing is certainly certain: there will be many unforeseen consequences. There are still many unknown unknowns, and there will be a lot of litigation arising as a result of this.